This is Barry Zalma on insurance. Today, I'd like to speak about construction defects and insurance. Construction defect suits flood the courts of North America in greater numbers every year. The book, Construction Defects and Insurance, made up of 8 volumes, is designed to help the property owner, builder, construction professional, insurer, insurance professional, construction defect plaintiff's lawyer, construction defect defense lawyer, and those who support them. Anyone faced with construction defect issues can use the series of books to effectively avoid or resolve claims of such defects. It covers identification of construction defects and explains how to insure, investigate, prosecute, or defend litigation that results from claims of construction defects. All buildings have an expected lifespan. None, except perhaps the Egyptian pyramids, were designed to last eons. Yet even the pyramids in Egypt will erode to a mound of sand given enough time, wind, water, and the movement of tectonic plates. Their demise will be an expected result of age and erosion rather than a construction defect. Venerable, well-constructed structures seldom fail because of their advanced age. Usually they are torn down and replaced with new structures before they have time to waste away. Regardless of the methods or materials used, all structures can fail before the end of their useful life. Such a failure can cause damage to people or property. The failure of a component part of a structure that causes damage to a person or property can be considered a construction defect. If the component was not installed correctly, was not appropriate for the structure, or was defectively constructed, the manufacturer, seller, and/or installer of the component parts may be held responsible for the damages caused. When structures fail, the damages can include, among other things, as has been recently learned in the state of Florida, a total collapse of the structure and injury to its occupants, an inability to keep rainwater out of the structure, cracking, settling, or subsidence of concrete flatwork, cracking, settling, or tilting of walls, doors that do not fit and close properly, windows that do not operate, walls that are out of plumb, walls, doors, and windows that leak, foundations that settle, crack, or subside as a result of subsidence or hydroconsolidation of the soils on which the foundation is placed, mold growth on floors, walls, and ceilings, acidic emissions from Chinese manufactured drywall, or damage to a person or property of third parties. Construction defect claims and suits are proliferating. Courts across North America are overflowing with multi-party lawsuits brought by condominium associations, Canadian strata organizations, owners of tract homes, and commercial property owners. As construction defect claims proliferate, it has become not unlikely that most people will either pursue or defend a construction defect claim at some point in their lifetime. The dollars involved in construction defect litigation have grown exponentially. If a problem exists in a multi-unit condominium association or a housing tract, minor repairs of the defects multiply over the various units to millions of dollars. In addition, The complexity of a construction defect suit usually results in hundreds of hours of work for attorneys and the need for separate counsel for each party defendant, like the owner, architect, general contractor, and each subcontractor. The settlements and judgments are often extremely large, and attorneys' fees generated in such cases with multiple parties are high, encouraging lawyers to file suit. The targets of construction defect litigation are many and varied. Construction defect claims can be presented to any of the following, like property owners, builders and contractors, buyers, sellers, part manufacturers, suppliers of material used in original construction repairs, designers, property managers, architects, engineers, geotechnical engineers and geologists, surveyors, subcontractors, real estate inspectors, real estate brokers and salespeople, or real estate investors or developers. So when a suit is filed and a deposition is taken, there may be as many as 20 lawyers representing 20 different defendants asking questions. It becomes almost ridiculous. I have sat in such depositions, and perhaps because the questioning was done in alphabetical order, I was the last to ask, and every question possible had been asked 3 or 4 times. So I just simply introduced myself and went home with a lot of time expended on the part of my client. The property owner who is faced with any construction defect has several avenues of recourse based upon legal remedies available in the United States. The remedies available to a person who has been damaged by a construction defect come under the various bases for such suits, beginning with common law negligence. Negligence has the same definition, regardless of the state where it is alleged. It has been defined as a legal duty owed to the plaintiff by the defendant, a breach of that duty, an actual injury to the plaintiff, and a showing that the breach was the proximate cause or a proximate cause of the injury. A breach of duty exists when it is foreseeable that one's conduct may likely injure the person to whom the duty is owed. The California Supreme Court upheld a judgment for property damage caused by negligent residential construction in Sabella v. Whistler, a 1963 decision. The defendant had built a house and offered it for sale to the general public. As it turned out, the defendant's negligent preparation of the lot, in combination with a subcontractor's careless plumbing work, later caused leaks, subsidence, and damage to the house. The purchasers sued for negligence. The builder, arguing unsuccessfully against the imposition of tort liability, held that the liability of a contractor should be determined by the consideration and weighing of the various factors bearing on liability. It was held, much to his damage, that the builder was responsible for all of the ensuing damages. The Nevada Supreme Court, in answer to a question posed by a federal district court, concluded that in a commercial property construction defect action, in which the plaintiffs seek to recover purely economic losses through negligence-based claims, the economic loss doctrine applies to bar such claims against design professionals who provided professional services in the commercial property development or improvement process. This was Terracon Consultants versus Mandalay Resort Group, a 2009 decision. Formerly, once a builder had completed a structure and the purchaser had accepted it, the builder was not liable to a third party for damages suffered because of the work's condition, even if the builder was negligent. The purchaser had remedies against the builder in contract and warranty. Injured third parties had no clear remedy until the Supreme Court of California, following the trend that began with McPherson v. Buick Motor Company, a 1916 decision of a New York appellate court, qualified the general rule exonerating manufacturers from third-party claims with an exception applicable whenever the nature of a manufactured thing is such that it is reasonably certain to place life and limb in peril when negligently made. The Supreme Court of California had already held that the manufacturers of defective ladders, elevators, and tires could be liable to persons not in contractual privity with them, yet foreseeably injured by their products. The Supreme Court therefore had no trouble applying the same rule to someone responsible for a defective railing in Hale v. DiPaoli, a 1948 decision of the California Supreme Court. On the other hand, in Arizona, the Court of Appeal in Karstens v. City of Phoenix, a 2003 decision, refused to allow plaintiffs to sue the building inspectors for negligence because there was no bodily injury or property damage suffered. The Court of Appeal justified its holding by expounding on the history of the legal theories requiring actual damage and said, quote, "In Arizona, it is well established that a homeowner may not recover in tort against a contractor for economic losses attributable to defective construction when the negligence has not caused personal injury or damage to property other than to the defective structure itself. Our Supreme Court first recognized the applicability of the economic loss rule in construction defect litigation in Woodward v. Chirco Construction, a 1984 decision. In Woodward, homeowners sued the builder of their house for both breach of implied warranty of workmanlike performance and habitability and negligence after large cracks developed in the house walls and foundation. The fireplace separated from the wall, a family room shifted forward, the kitchen ceiling began to bow, and the floor warped. On appeal, this court affirmed the dismissal of the negligence claim, but reversed the court's ruling on the implied warranty claim because the 6-year statute of limitation on that claim had not expired. Close quote. A plumbing contractor had a general duty under tort law, separate from any contractually assumed obligation, to exercise reasonable care in any work undertaken, including precautions to avoid dangerous gas explosions, in a case called Valley Forge versus Sam's Plumbing, a 2009 decision of the Arizona Court of Appeal. In a California case, a contractor who was renovating the insured's bathroom accidentally drove a nail through a pipe while hanging new drywall. The nail caused no leak at the time and went unnoticed until years later, when corrosion around the nail caused a leak as well as extensive water and mold damage. The insurer denied coverage on the ground the damage arising from third-party negligence was excluded whenever it interacted with an excluded peril, including corrosion or leakage of water. The insureds filed suit arguing that the contractor's negligence in driving the nail through the pipe was a covered peril and was the efficient proximate cause of their loss. Under the efficient proximate cause doctrine, when a loss is caused by a combination of covered and excluded risks, the loss is covered if the covered risk was the efficient proximate cause of the loss. On appeal, the court noted that the efficient proximate cause doctrine was superseded by the California Supreme Court's analysis in Julian versus Hartford Underwriters, a 2005 decision of the California Supreme Court. In Julian, the court held that an insurer is not prohibited from drafting and enforcing policy provisions that provide coverage for some but not all manifestations of a particular peril. The court held that the homeowner's policy effectively excluded coverage for consequential damage arising from a contractor's negligence, a covered peril, whenever it interacted with an excluded peril, such as corrosion or water leakage. When a loss is not excluded under the policy, coverage exists under the ensuing loss provision because there is no rule of law excluding coverage under an efficient proximate cause analysis. The insurer is precluded from changing the grounds for its denial of coverage, and there is no basis for a jury to determine efficient proximate cause of the loss. The dispositive question in analyzing ensuing loss clauses is whether the loss that ensues from the excluded event is covered or excluded. If the ensuing loss is also an excluded peril or an excluded loss under the policy, there's no coverage. But if the policy covers the peril or loss that results from the excluded event, then the ensuing loss clause provides coverage. This was Vision 1 versus Philadelphia Indemnity, a 2012 decision of the Washington Supreme Court. There are other tort remedies, such as strict products liability, that will be covered in future videos. This video was adapted from my book, Construction Defects and Insurance, Volume 1, which is the first of an 8-volume treatise on construction defects and insurance, available as both Kindle books and paperbacks from Amazon.com. If you found this video to be interesting or useful to you or your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel, my blog, and my Substack publications so that you can learn about future blog postings on insurance and future videos. Thank you for your attention.